A very good morning to all of you. I think we can start with the session, or the participants can join in between the session. A very good morning to all of you. My name is Advocate Varun Kumar. I am a founder and owner of Law Audience Journal. Today we are organizing a webinar session on IP licensing in the digital age, and today we have a very special guest with us, Isha Sharma ma'am, who is a director and founder at Trayambak Overseas Pvt Limited. She has a vast experience in the field of intellectual property law, patent, trademark, and etc. And I hope you all must have read about the speaker in the official notification also. If any one of you have any doubt, you can raise your hand in between the session. If the speaker allow, we can answer your query. Otherwise, you can ask your question at the end of the session. So I request Isha ma'am, please take over the session.
Thank you so much. Thank you for the introduction as well as for inviting me. So, I'm not aware about the background of the speakers, but we'll try to cover it as I would say, little easy to understand as possible, because the kind of topic and the discussion that we're going to have is little technical in nature. So regarding the questions, maybe we can keep it as an interactive session, or if you want to keep it in the chat box, we can have the discussion at the later stage as well. So Varun, if you allow me, can I share my screen?
Yes, ma'am, you can.
Okay, just a second. Let me know if in case it's visible, if the presentation is visible.
Yes,
Is
it
it
is.
visible?
Yes, it is.
Okay, great. So I'll skip this part as the introduction is already placed. A little heads up on the fact of my background is that I come from technology field, and then later on I entered into legal. So I've done 2 masters, and it's been around 15 years working into intellectual property domain. So what we will try to do in this session is a little bit of basic understanding about IPR, and then we'll move to the topic under consideration. So let's start with understanding what is intellectual property. So before that, I want you to understand that what are the different categories of property, because this is the kind of question which comes on a very frequent manner where people don't understand that what is intellectual property. So they feel that maybe it's a piece of land or any sort of a property that is being held in the form of a tangible asset as well. So the property is usually divided into 3 categories. One, we have a movable property. Immovable property, as the name suggests, something that you can move from one location to another. Movable property, so anything that you have in the form of your laptops, car, pen, or any digital gadgets can be a movable property. Immovable is going to be something which is fixed at a particular area. So if you have your office building or your residential building or anything which is fixed at a particular location which cannot be moved, as your immovable property. Then we come to the intellectual property. So usually anything that you can create by application of your mind will fall under a intellectual property category. So that is usual definition, that whenever you use your human intellect to create anything new which is not already present in the public domain can be considered as a intellectual property. So this is a question that I would like to ask everybody around you. So the question says that all I asked was, can I patent my copyrighted trademark? If you allow, Varun, I would like to take some leads, that if anyone of you can tell me what is the missing part in this picture. What is wrong with this question? Can anybody tell me?
If anyone wants to speak, please you can
If
unmute your
anybody
mic.
wants to participate, they can. Otherwise, we will discuss this once we are complete with the session. So let's keep it that way then, that after the session is complete, I will ask this question again, and I believe that you will be able to answer. So moving ahead, as we were discussing the types of intellectual property and the property, so we have different categories divided into law, according to which the subject matter which is under consideration would be covered under a relevant IP. So when I say that, say for example, if there is any book or a software which is being created or any lyrics that you have written, all of that will fall under a copyright subject matter. Then we have patent applications which are primarily for any sort of innovation which is divided into a product patent or a process patent. Then we have trademarks which are given usually for brand names, logo, slogan, tagline, anything associated with the brand which might distinguish one entity from the another entity. Then industrial design is usually for the look and feel of a product. So anything which is aesthetically appealing to you might fall under design registration. Then we have GIs, which are associated with a particular location or a geography, due to which the products acquire a distinguished or a characteristic feature or I would say properties. So for that reason, GI can be filed. And GI is not an individual right, it is a community right. Trade secrets, anything which will not be filed under these categories, but you want to keep it as a confidential information will be considered as trade secret. Right now, we don't have a law related to trade secret, but it is under the process. So eventually, over the years, we will have one. Semiconductor layout designs, that's for chip design. If you have a chip design, then you can submit an application under the semiconductor law as well. Then we have plant variety protection, which is specifically for the new plant breed varieties, and the protection lies from 15 to 25 years. These are the categories, but more or less in your realistic life, you will come in interaction with initial four. So copyright, patent, trademark, and industrial designs are primarily the ones where most of the applications are being filed. And as we are moving on more towards the digitization, these things will be more implemented with the kind of work that the market on the industry is being doing. So to make you understand about how to segregate the different subject matter with respect to IP, so usually we can take any example around you, say a laptop or your car or your mobile phone, that is little easier for you to understand. So all of us use a mobile phone, and the mobile phone is associated with a particular brand. Say for example, I'm using Samsung or somebody is using Apple or OnePlus or any other brand. So the kind of brand name that they have or the logo that they have will be falling under a trademark category. Anything which is under that mobile phone in the form of softwares, in the form of user manual, ringtones, images, will be covered under a copyright law. The technology behind it, if you feel that there is any kind of a technical feature involved into it, all of that technology with respect to the product and process will fall under a patent application. And the look and feel of a mobile phone, like we have a fold mobile phone or we have one touch mobile phone or we have a different kind of a look and feel with the keypad placement kind of a mobile phone, or you can take it an example of your cars. So every car design, the outer appearance of the design is different from another, so they file a lot of design applications to protect that. And then the trade secrets, which is not known. So basically, if there is anything which cannot be filed in these form of IP, somebody is going to keep it as a trade secret. So that's a very easy to understand kind of an example, and I hope that was helpful for you to understand that what are the different categories of IP. So why to do so? Of course, the one reason for filing any sort of IP is that you get an exclusive right, which means you are going to exclude others to do so. So it's not basically for you to do so, but you don't want anybody else to do the same kind of invention that you have created, so that it will create any kind of a commercial damage. So the exclusivity right is there. Then you can commercialize it by doing licensing or technology transfers or selling it off assignments. So that is something that you can do with respect to your IP. If you want to do your own business out of that particular IP, then the valuation will increase and the trust will increase. So what happens is that if you have for example, you have a startup. Now, when you go to an investor, the investor will usually ask for the valuation of the company before funding in. Or if you're going for any merger acquisitions, then also it will be there. So it is said that the IP contributes about 75 to 80% of the valuation of the company. So if you have your brand name registered, your copyrights in place, your patents in place, that will increase the valuation of your company and automatically builds the trust. So if you have two products, one product says patent granted or patent pending, and one product doesn't say anything. If you have to compare for both, your mind will run in a direction where you will automatically feel that it might be a case that the patented product is advanced version, or it is something which is unique there, and that intends you to buy that product. So that increases the trust. And sometimes it acts as an advertising tool as well. So people promote their businesses by saying that we have a patent pending or a TM status, which is trademark pending. So that also works well. So usually these are the reasons why IP is being filed. A little bit about patent applications. So patents are basically rights which are given to the innovator for a period of 20 years and under certain conditions. So, what is happening is that an innovator is creating an innovation. They are submitting the application in the government department. Government is giving them a certificate for a defined period of time that, okay, fine, you are the creator for this thing, and you will have that monopoly right on an exclusive right for a period of 20 years, provided of course it qualifies with the criteria of patentability and goes under the examination process. But once it is being granted and it is valid for 20 years, you are the rightful owner. Anybody else using the same technology without your permission will fall under the infringement bracket, and you can take an action against them. So, how do you qualify that whether it is going to be filed as a patent application or not? So, we have three aspects. One is novelty, one is inventive step, one is industrial application. So novelty means that if you create something new, say for example, a smartwatch is created for the first time, and this smartwatch I need to file for a patent application. What we'll do is I will conduct a search which is done on global databases to cross check whether this smartwatch is already being patented by somebody else or not, or already existing in the public domain or not. So if it is not existing, then my novelty criteria is fulfilled, I can file. Then I'm going to see whether it is the smartwatch is a byproduct of my own creation, or I have I done a combination of multiple resources and articles and then landed upon the same thing. So what it usually means that it should not be obvious to the person skilled in the art, which means that if I come from an electronic background or biotechnology background or any other background, the invention related to that background should not seem that you haven't done much. You maybe combine few references and landed upon this thing. So that is one. Then the industrial applicability. Industrial applicability means that it should be capable of being made. It should not be an abstract idea as such. So these are the usual factors you consider before filing an application. Then we have certain sections which doesn't allow a patent application to be filed even if you qualify the patentability criteria. So what are those sections, or what are usually defines is anything which is a frivolous invention cannot be filed. Anything which is against the public order or morality cannot be filed. Anything which is a discovery cannot be filed. So I hope you understand the difference between discovery and invention. Discovery is something which is already existing, you just found out that it exists. And invention is when you create something by application of your mind. So inventions are allowed, discoveries are not allowed. Any living or non-living substances occurring in nature, you cannot file for an IP for them. Then anything which is already existing but you found out a new use or a new form of the same thing, that can also not be filed. Like for example, crocin used to treat maybe fever or body pain, and now you feel it can cure cancer as well. So that cannot be filed as it is only a new use, unless you prove that the composition, you have changed that composition, or you have incorporated some changes in the composition due to which it is producing those type of results, then it can be considered. Mere admixture cannot be considered. Like you combine two things, there are two drugs that you combine with each other, both drugs are having their independent property. Once you combine them, they will act in the combined property format, so that cannot be allowed. But if it produces a synergetic effect, which is basically a out of the blue kind of an effect, then you can try to consider for filing a patent application. Then India is a restrictive country when it comes to agriculture, horticulture. So methods related to that cannot be filed. Methods related to medical, surgical, diagnostic, treatment methods cannot be filed, but the products can be. So in the same process, if you are creating a device or a product, it can be filed for a patent application, but process cannot be filed in a patent application. Then anything which is related to a computer or a mathematical or a business method cannot be filed for a patent application. This is very important because as we will be discussing today's topic, it is going to be focused everything related to AI, computer programs, algorithms, and so on. So, if the invention is under consideration of this category, patent applications are not the right form of IP to be filed unless there is a hardware integration which makes it as a product format. So, if it's only a method or a process, then it will fall under a copyright subject matter. We'll discuss that eventually. Anything related to literary work, dramatic work, musical work is going to be filed under a copyright law. Then anything related to method of presentation, integrated circuits, traditional knowledge, everything will fall under a non-patentable subject matter. So how to proceed further? If you qualify the criteria of patentability, then for proceeding further, we have to draft the application. So whatever you have created, you cannot submit it as a prototype format. So if the smartwatch was created for the first time, I cannot submit the smartwatch as it is saying that this is what I want to file a patent for. You have to write in a very detailed fashion, which is a techno-legal document, drafting, patent draft, and then you can submit the application into the patent department. They will evaluate the application. Before that, it goes under publication. If they have any discrepancies, they will cite that. You appear in the hearing, and then post that a certificate is being granted. So this is the usual process that is being followed. Now, one question that is usually asked and people confused because it's kind of a key takeaway when you intend to do a patent application is when to file for a patent application. So usually people feel that once they launch the product into the market or they will gain some commercial aspect out of it, at that point of time they will decide that they want to file for a patent application, which is not possible. So there is a timeline attached to everything when it comes to IP. So regarding patent application, it should be filed before the launch of the product, before it goes into the public domain. Either you are disclosing it to the public domain or it is already being done in the public domain. At that point of time you cannot file, so it has to be before publication. You need to file your patent application, and once you get a patent pending status, at that stage onwards you can go ahead and do the submission of the publication. So if you're going for any paper publication or display it in any sort of exhibitions or maybe start selling with the product, try to file your patent application before, otherwise it might not be possible for you to get it later. Then we'll discuss a bit about designs. So designs, as we were saying, that those are the aesthetic appealing products which can be filed for the look and feel. So anything in the format of 3D representation of a product can be filed, 2D designs can be filed. But the criteria is that it should be new and novel. It should not be already made in the public domain or being disclosed by you in the public domain. So in the similar line of patent application, design also needs to be filed before you make it public. Right? Anything which is the functionality part of design will fall under patent, so you cannot file for a design application. Anything which is scandalous in nature, obscene in nature, offensive in nature cannot be filed as an application. Anything which is against the public order or morality cannot be filed as a patent application. A design application. So to give you certain examples, these are the design applications which are filed by the companies and granted as well. So these are actual design application. So this is a design of an AC which is being filed by Voltas and granted to them as well. This is again an AC air conditioner filed by a competitor called Daikin. They also got a design registration. So you can see that even if you make the edges curve, it is a different design. So all of that can be filed as a design application if the look and feel is different. So this is a water dispenser by Voltas. Again, application is being filed and being granted. So that gives you a fair idea. Other than these, it's not only for electronic industry, for your jewelry, for your furniture, any industry that you can think of is coming with a product range which is appealing in nature can consider to file a design application. Now we'll discuss a bit about copyright applications. So copyright usually are categorized into different subheads like literary work, films, dramatical work, musical work, artistic work, and sound recording. So depending on the category that you have created, you can submit a copyright application, and the statutory fee also depends on the type of the application. Like if you want to file for a literary work, it's pretty less. When you want to file for a film and dramatic work, it's slightly more. Anywhere between 500 to 5,000 rupees is usually the range. But for checking the exact fee structure, you can go to IP India website, and everything, the forms and the fee schedule is available there. So what is the usual process that we need to follow for a copyright registration is that we file an application. The filing would be done on IP India. So all your IP rights are being filed on IP India. So for patents, designs, copyright, trademark, you need to log in there. If you have a digital signature and you are the applicant, you by yourself can also file an application, or you can hire a registered patent agent or a design agent or a trademark attorney to go ahead and submit your applications. So once that is being done, they will evaluate the application. If there are any discrepancies, they will ask you to reply to them, appear in the hearing, and then post that certificate is being granted. So trademarks, anything that you see around you will be a trademark application. So the kind of shampoo that you use, the spectacles that you use, the clothes that you wear, or the shoes that you wear, the car that you drive, the laptop that you use, everything is associated with a brand name. So all those brands file for their brand names as well as their logos so that nobody else starts using that and might dilute the brand image at a later stage. So, what is a trademark application? Applications are usually a sign capable of distinguishing one entity from another, which might be categorized into goods and services as well. So, once we file for a trademark application, we write TM, which is trademark pending. And once it is registered, we write R within the circle. That means that the trademarks are granted. So type of trademark applications are word marks and logo marks. So word mark means that anything without the styling attached to it. So say for example, I want to file Samsung as a trademark application. So Samsung in a color combination of blue and white in a particular font will be filed as a logo application. And Samsung as it is a word without any styling attached to it will be filed as a word application. So that can be considered. Then there are different classifications attached to it. So from 1 to 34, the classifications are under the goods category, and from 35 to 45, we have classifications as a service category. So if you like any airlines that you want to fly with, it will be a service provider. So the trademark application of an airline will fall under anywhere between 35 to 45. If you are buying a product of a company which is into clothing category, that will be a goods category, so it will fall under anywhere between 1 to 34 depending on the relevant classification. Trademark process, pretty much the similar of what we have discussed for other forms of IP. We will conduct a search to cross check the availability. Post that we file the application. Post that the examination will happen. If there are any discrepancies, examiner will cite those. Then it gets published for about 4 months period where any third party can oppose the application. If there are no third party oppositions, the trademark applications are usually being granted. It is valid for 10 years and then it can be extended for next 10 years as well. So it's kind of an ageless asset provided that you keep the renewal in place. Now we'll be discussing a bit about the topic itself. So today's topic where the discussion will happen is more on the IP licensing in the digital age. So first of all, we will try to understand that what is IP licensing and how you can utilize it in different forms of IP that we have discussed eventually. So let us first try to understand what is a license. So, say for example, X entity holds an IP, which is the granted IP to that entity. Now, X entity wants to commercialize the IP in different forms. So, one option is licensing, another option is that you can give a franchisee model, third option is that you can give a transfer model. So, in licensing, what happens is that the X entity stays as an owner of the IP, but it is going to give a license to the Y entity to use it on certain terms and conditions. In a similar manner, where you rent a house, so the house ownership stays with the owner, but somebody who wants to stay in that premises or a location comes and takes it for a rent. They pay certain rent to them under a defined terms and conditions, which can be maybe for 1 year or maybe for 6 months. This is going to be the rent. You cannot change certain conditions. You cannot. There will be a fixtures attached to it. What all conditions you want to mention. So, in a similar line, the licensing will also follow, where the X identity will give a license to the Y entity and there will be terms and conditions attached to it. So, what are the key components? There will be a licensor who is the owner of the IP, licensee to whom the license is being given, and the agreement that you're going to sign between two entities are going to define a lot of components into it, which will include like scope, duration, territory, compensation, and so on. So we'll discuss it eventually. So when an X entity decides to give a license to the Y entity, there will be an agreement in place. And the agreement will define lot of factors, and which is going to be an important aspect while we do the licensing part to it. So, what are the components of an IP licensing agreement? One is that it needs to define the parties. So, who are the parties? If somebody is owning the IP, then the address, name, everything will go there. Then, to whom you are giving the license, licensee, name and address will be mentioned there. Then, the roles and responsibilities of each party needs to be mentioned in detail to them. Then the definition of IP, like which IP is under consideration. Are we talking about patents? Are we talking about trademarks? Are we talking about copyrights? Or is it about like the entire portfolio of patent applications, or maybe just one patent that you're giving for licensing? Everything needs to be written in a detailed fashion. Then scope of the license, then there are different types of licenses that you can provide. One is an exclusive license, which means that X entity is only going to give a license to Y. There is not going to be any third entity that will be involved at a later stage. So it's an exclusive sole license which is given to them. Just excuse me for a minute. Then we have a non-exclusive license, which means that the X entity is going to give a license to Y, but it can also give to ABC as well, which is a non-exclusive license. That okay, fine, I'm letting you also use this thing, but I will probably give the same license to other entities as well. So that is like a restrictive license. People usually don't prefer to go for a non-exclusive license if it is a technology that they want to introduce into some other purpose. So those are the type of licenses that you should consider. Then field of the use, that under which specific industry do you want to utilize it. Like sometimes a patent application is so broad that it might be used in a maybe in agriculture industry, and it might also be used in any other industry as well. So whether you want to give license to only one particular application or you want to give it to multiple applications as well. Then territory, which is again a very, very important aspect, because all your IP rights are territorial in nature, which means that it is given for a particular geography. So if a patent application is being registered for India and maybe it is also registered for other countries, and you want to give a license, you want to decide whether you want to give license only for India or for other countries as well. And accordingly, you can work out on the royalty or the commercial aspect of it. Then the duration of the agreement. Do you want to keep it say for 1 year, or you want to keep it for 5 years, or you want to go by leasing models, or you have renewals options being available or not, you want to reconsider once it is being terminated at that point of time, you want to reconsider. All of that factors needs to be mentioned more specifically. Then the licensing fee and the payment term. This is I believe the most important part because everything lies there only. So the fee options can depend on different stages. There can be an upfront fees, that one-time fees I'm going to pay for you, and then I utilize it for this duration of time. Milestone-based payments, you can define that once you achieve this or you do this, at that point of time, this payment will be made, and after a regular interval of time, milestone payments can be achieved. Royalties, which are percentage of sales, and then there are other models as well which you can use. So royalty, a percentage, like every industry is having a different percentage attached to it. So it can be 1%, 2%, up to 5 to 10%, depending on the industry. You can decide the royalty rates. So payments can be decided. And if you're working with any other geography, then maybe you need to define that under which currency you will be taking the payment models, and you also hold the audit rights. So what usually happens is that you don't know that how much money are the licensee is making, if it is royalty based or if it is milestone based. Then you should also have an audit right, so that the licensor can actually audit the premises of the licensee and see that how much revenue is being made, and basis on that the payment can be made. Ownership and right, because we are discussing only licensing, I believe that you should know that the ownership still stays with the licensor only. The owner of the IP is just giving a permission to use it. They are not giving you the ownership of IP. So further sub-license, whether you can do it or not, needs to be defined. Assignment cannot be done any which way because the ownership is not being transferred. Other clauses which can be introduced in a licensing agreement is you can keep your confidentiality clause, which I believe is a must in every agreement that you sign. Infringement handling. So what happens when a third party infringement comes into picture? Who is going to be held liable for the litigation cost and that particular infringement? So that needs to be defined properly, that who is going to take care of it. Warranties and representations can be mentioned. A little generic clauses when it comes to agreement. Indemnification can be mentioned, and termination clause. So termination clause also needs to be taken very seriously, that who are the people who can terminate the agreement, and what are the post termination rights and obligation, because once the agreement is terminated, the consideration amount or the payment gets conflicted. So at that point of time, if you have written that what is going to happen once the termination is being done, the kind of obligations and rights that are being held, and the payment models that needs to be made, it becomes little easier for the implementation to happen. Then the dispute resolution, so which is going to be the geography, whether you are allowing mediation proceedings, arbitration proceedings, or court options to for the relief when it comes to breach of contract, that can be mentioned. And the performance obligations and derivatives and improvement, that usually happens is in patents and copyright. Once you have an IP, if there are any modifications done, so there are, like, if I talk about a software, it is going to be constantly under an improvement stage, so there will be new features added and every single time. So you would like to mention that part, that if improvement happens, who is going to be utilizing the same aspect as well. The benefits of IP licensing, when is it usually done? So at the time of revenue generation, if somebody holds an IP and they want to make money out of it, they can do so. Market expansion, most of the time what happens is that one entity is not capable enough to enter into multiple geographies, be it state level or be it internationally as well. At that point of time, they prefer to give it as a licensing model so that they can generate money also and enter into multiple locations. For merger and acquisitions, IP licensing are important, and innovations and incentives, which is basically means that if you're creating something, you are making money out of it. Of course, you will keep on creating other aspects as well. Territory and global reach, as I said, that the licensing should very specifically say that whether it is going to be for one country or it is going to be for multiple countries or cross border, because IP is territorial in nature. It needs to be defined, otherwise there can be a huge implication on the global reach part of it. Then there are certain licenses which are open source licenses, which means that they will give you a free edge. So open source licensing is a legal and a practical framework, mainly in the direction of software. So software developers, they are kind of free to operate for on the open source code licensing option, where they don't have to pay too much of money. They can use those open source codes and make create their own things. So software code made available for free use and modification, you can do that. Those are available. Examples are GNPO and an MIT license. So the type of open source licenses are two. One is a permissive license where few restrictions on the user and redistribution. So it basically allows the proprietary software to be used by the developers. So anybody can come and use our open source licenses and utilize it to create further things. Then there are some copyleft licenses which requires derivative works to remain in open source under the same license, but the reciprocity manner, which means that you can use mine, but maybe I can use yours as well. So all of that can also be done. So these are certain types of licenses. Maybe I can share the presentation that will help you at a later stage. So new legal framework needed. Usually what is happening is that, at least if I can talk about India, there are a lot of restrictions when it comes to software based innovation. So there are a lot of countries which allow a little lenient way to grant software based innovations. So under the patent law. So India is being, I would say, under consideration, where they might make some changes to incorporate the patent related part when it comes to softwares. But for the copyright, it is very well settled. Now, again, there is one aspect of law which is data privacy. So that is still under question. I believe everybody of you are hearing nowadays of data frauds and impersonation and maybe hacking and doing the bank account freezing part of it. So all of that can be protected if we have the Data Protection Act in place, which is still under consideration. Rules are pending. Once it is being going to be implemented, we will be in a better situation to handle it apart from the IP. A little bit about the copyright and music industry. How it works is that in the copyright, every owner is given a different license attached to it. So if you're a lyrics writer, you will have your own copyright protection. If you're a singer, you will have a different copyright protection. If you're a composer, you will have a different copyright protection, and all of that can be licensed to utilize it in a format where the commercialization will happen. So what happens is that there are certain university societies which are formed, and every society's function is to have a different subject matter under copyright being given for a license. So every singer cannot come and give license to other entities. So what they have formed is certain societies like IPRS is an Indian Performing Rights Society, which represent lyricists, composers, and publishers. So the rights are given to them. Anybody who wants to use those for any public appearances or public use can approach those societies and take a license from them and utilize. So anything with respect to radios, live streaming, live events, they take a permission from these kind of societies. Then we have societies which are given for singers. So ISRA is Indian Singer Right Association, where if you are using any performers, singers, right, then you can go and take a right from them as well. Then the other platform owners like Hangama, your Saban, Ghana.com, Spotify.com, or Apple Music, all of them are also obtaining license from these bodies, and sometimes they are taking license directly from the production houses or the labels which are not falling under these societies. So there are some independent labels as well, like Sony Music is an independent label. So they also give their direct licenses, but you have to take a license from them. If you don't do that, then they might send you a copyright infringement notice as well. So for different reasons, you can approach different societies, take a license from them, and then utilize the same thing. Right? Like for example, one example is that for online streaming, which includes OTT platforms and YouTube, you can take IPRS license and PPL license. So that will safeguard you. Then there are certain digital copyright management systems that are being incorporated. So those are kind of, I would say, software-based platforms which protect and track the enforcement of copyright application. So what are they doing is they control the access to the copyrighted digital content that if you're using copyrighted protected digital content, you might receive a notice attached to it. They track the usage, enforce the licensing terms. So if there are any licensing agreements which are being done, everything will be installed there and they get to know the licensing terms. And it automatically prevents an unauthorized and duplication on distribution part of it. Not very common. I would say it's usually accepted by the companies who are very much into the copyright subject matter. At a level of influencers or regular users, it's not very easily accessible kind of tool. So there are different, I would say, categories of copyright application when it comes to digital stage. So one is streaming. So if there is any streaming involved in IP, there will be like multiple forms of IP associated with it. For example, copyright that protects the content of a movie, music, or shows are needed for a legal streaming. Licensing would be needed whether you are taking an exclusive license or a non-exclusive license. DRM, as we discussed right now, to prevent the copyright piracy part of it can be checked. If there are any trademarks being used, if you are using brand names, whether the brand has given you permission to use for that or not. So brand names and logos will be needs to be taken a permission for. So all of that will fall in the picture. Then for ebooks and digital publishing, again, if it is your creation, you can file your own copyright application. If you're using somebody else's creation, then you have to take a license from them on every aspect. So for a title of a book or a digital publishing, the trademark license needs to be taken. For the content part of it, layout, design, everything, a copyright application license would be taken. And in a similar way, you can utilize it. If you don't do so, again, as I was telling you, that the infringement might be considered. In a gaming industry, like a lot of characters are being created, a code is being created. So in a gaming industry, there is going to be an app or a website which is going to implement everything. So for that part, also you're going to file for a copyright application. For the characters, you are going to file for a copyright application. For the music, story, art, you're going to file for a copyright application. In the same way, the names and logos and branding part would be protected by a trademark. If there are any new unique mechanisms or technologies which you're going to implement in a gaming industry, it is going to be protected under a patent law. So all of that can be considered. Then in patent applications, as we are moving in the digital world, so as we were discussing that softwares alone cannot per se cannot be filed as a patent application, so it is considered under copyright law. But then there are a lot of standard essential patents which require FRAND licensing. As we are discussing the licensing, this also becomes important mainly in the patent category. So what is SEP? SEP are standard essential patents. So standard essential patents are the patents that claim invention that must be used to comply with the technical standard, which means that the technology was new for which a patent application was being filed. But now it has been made as a technical standard, and without using that standard, nobody else will be able to use that or maybe create something on top of it. So once you create an invention which sets the standard, then you have to comply with the FRAND license as well. So the kind of inventions which got under SEP category were 4G, 5G wireless communication, Wi-Fi, and then USB, Bluetooth. So these were setting the standard kind of an innovation. So once you do that, then there are authorities which sets the standards of an organization that what are going to be the standards, and then there are going to be the organization which sets the FRAND licensing models for that particular country. So FRAND license means that if you have an SEP based innovation, which is standard essential patent, then you need to be fair, reasonable, and non-discriminatory while giving the license. Because what will happen is, say for example, X entity has an SEP patent, right? Now they can maybe charge like unreasonable amount of figure for giving a license. So that cannot happen. There has to be one body which is going to decide that okay, fine, you are the owner, but you cannot decide for something which is going to be unreasonable. It has to be a fair and reasonable licensing fee. You charge that and then make money, but you cannot be unreasonable. So those are called FRAND licenses. And in India, we have Competition Commission of India (CCI), which is holding the funding licensing part of it. That what should be the fair use category and according to which it is going to be implemented. So those are also very important when it comes to patent applications, licensing models. Then we have digital piracy, as I believe that everybody of you know already what is digital piracy. So anything which is downloading or streaming of a copyright content without permission of the owner, it is considered as digital piracy. Anything which is sharing pirated files, even if you are maybe say a WhatsApp group admin and you are putting it on a WhatsApp group where there are multiple people without the authorization, it is still considered as digital piracy. Cracked versions of softwares, if you use that, it is going to be digital piracy. So if the owner gets to know or the company who's owning the IP gets to know, they might be sending a legal notice. So all of that needs to be considered very, very seriously. So peer to peer, if you transfer anything which is unauthorized, it is piracy. Streaming piracy, unlicensed streaming is a piracy. Software cracking, as we have discussed, that if there is any software for which there is no license being taken or subscription fees being paid, it is going to be a digital piracy. And at least in softwares, people or the companies take it very seriously. So if there is a cracked version of a software being used, then the legal notice probability is going to be very, very high. Then recording movies in theater and distributing them online, again a digital piracy. Mobile app piracy, if you're using Android processing kits which are not from an authorized use, again into digital piracy. So all of that needs to be avoided in the digital stage, at least in terms of IP. Then once we are deciding the revenue model, as we were discussing that in the licensing agreement, if you are adding revenue models, that how the money is going to be implemented between the two parties, what you can do is you can have a royalty based lump sum fees, are we have already discussed. Then subscription based models can also be made. So if there is a software licensing which is being done, you can say that you're going to take a subscription for a defined period of time and this is going to be the amount that you're going to pay me. Franchisee models can be done. Cross licensing can also happen. So X entity gave a license to Y entity. Y entity was also an owner of an IP. Y entity gave a license to X entity that okay fine, let's have a mutual sharing model without any money consideration or maybe a bare minimum money consideration. So cross licensing can also happen per pay or per use or per sale, it can also happen, and sometimes on advertisement as well, which is not a very regular kind of a practice which is being done. Then there are some monitoring tools and compliances tools which kind of monitor the IP licensing part of it. So all of those tool information is available readily. I'll share that information with you due to paucity of time. Then some negotiation tips when you are signing an agreement. I would say that there are certain aspects that you need to consider so that the better negotiation can happen. First of all, you need to know your IP valuation in place. So even before going for any licensing, try to get an IP valuation done where if you have a brand name, what is the actual worth of your brand name can be done by IP valuation. Those are done by registered valuers. They can derive actual value to your product. So that should be done ideally. Then define the clear terms. Try to keep it as a both side kind of a mutual agreement. Don't keep it one sided because then it goes into multiple iteration process of changes. Try to keep it in a way where the other party is also utilizing the same thing. You are also on a beneficial side. So win-win kind of a situation. Audit part. Audit compliance is very mandate. So the licensor should always have a audit access so that they can get to know what is the royalty amount that can be done. So the sales figure can be monitored. and the royalty can be decided wisely and maybe renegotiated as well at a later stage. As we discussed, that the termination clause needs to be decided very, very properly. And what are going to be the tax implications, or if in case any breach happens, then related to confidentiality agreement needs to be mentioned. All of that can be written. So those are the some tips which are available. Then there are some licensing platforms available. So on the digital platform, there are certain sites and portals available which gives away the license. So if you have created a software, you want to give a license to somebody, you can use those marketplace. Or if you have a patent application, you want to give it for a license, you can use the marketplaces. So you can cite your IP there, and if somebody is interested, they can take away the IP and take a license for that. And the other way approach is that you approach to an industry or to a potential person of an interest who might be interested in taking a license. So that can also be done. Right. In terms of global, whenever you are writing a IP license, then you need to mention the geography in detail. So whether it is for India, whether it is for US, whether it is for Europe, you need to mention. Currency you need to mention in a very particular format, and the tax associated with it. So what usually happens is that every country will have a different tax system. So whenever you are signing any kind of a global IP licensing, there is a very strong consideration that you need to put on the taxation part of it, because that will decide that how much money will go into the taxation and how much will actually come to you. So tax and the currency is something that you should keep it as a priority part as well. Then language barriers, because most of the countries accept English, but then there are certain countries which sign their agreements in their local language. So once you're doing the translation, it should be validated and verified as well in that particular language. So that is something you need to take ahead very seriously. Then AI and IP licensing. So usually there is a discussion going on where people or the countries are discussing that if AI generates something, so human generated AI and then AI software maybe generates something of its own. So who is going to be the owner of the IP? Can AI be the author? Can AI be the owner of an IP in a copyright or a patent application? So most of the laws across the country says that it is going to be a natural person or a human who is going to be the owner of the IP. So if it's a human who created AI and then AI created something, then the ownership still stays with the human. So that is something that most of the countries are still following, but it might change with time. So we are still looking forward to it, what will happen. So that is there. And currently, all the AI tools which are there are still considered as a normal software. So when it comes to licensing of, say, maybe Chat GPT or DeepSeek or something like that, it is still considered as a software, and basis on that only you can create the licensing agreements. In a metaverse, again, I would say that all the 3D images that you create, avatars that you create will be a copyright subject matter. So copyright needs to be filed. Then we have a lot of discussion on NFTs and blockchain technologies, how we can incorporate those things into the entire legal system and how we can use it. Uh, Even the real world brands, like say for example any big brands, if you are utilizing their logos in the metaverse as well, their products in the metaverse as well, you have to take a license from them for metaverse as well, because that is being already being protected. So again, I would say the IP ownership will play the entire part, and licensing can also be done for the metaverse part as well. So I think that is it from my side. Now I'll be open to questions. I try to keep it within the timeline. Just a second. So if you have any questions, maybe you can raise your hands or I can read it in the chat.
There's one question from Udaya Vani.
Okay, there is a question: with the rapid growth of digital content and platform, how can a creator and write holder ensure effective enforcement of IP license across jurisdictions, especially when dealing with issues like unauthorized use or AI generated content. So this question is actually divided into two parts. For global or jurisdiction across the jurisdiction, as I was telling you, that IPs are territorial in nature, which means that if you want to protect it in any other country, you have to file there. For copyright, fortunately, under Berne Convention, if you protect it under one country, it will also be protected under all the countries which are under Berne Convention. So that is kind of a global in nature. Other than that, all IP rights, your trademark applications, your patent rights, your design rights needs to be filed in that particular country to be able to use that. Regarding the unauthorized use, so it is usually said that the owner who got the IP, it's their job to keep a check on who is going to use it in an unauthorized fashion. Till now, only in the authority stage, when you are filing for any form of IP, once it is being granted, till the point of grant, if there are any marks which are present, already present, or if any technology with respect to patent applications are already present, they will not let the similar thing being granted. This is the only check that they're doing till the grant part. Once it is being granted to you, it is your responsibility to keep a due diligence on it and try to see that who is using the same thing without your unauthorized use. So if you happen to get that information, you have to take a legal action against it. And in terms of IP, we have all the provisions available. We have civil remedies, we have criminal remedies. So depending on what kind of interest do you want to show, do you want to take off the damages from that party because you're using the similar kind of IP without authorization, so you can sue them there. Or if you want to teach them a lesson, you can go into criminal remedy as well. So the onus lies on the owners of the IP that you have to be diligent enough and then take a action against them. So authorities will not do it for you. Then in a same level, there are like multiple, I would say, government departments where you can do so. So if you're into export and import, you can do your IP registration at the port level as well. So then the authorities will not let it pass through the international medium. But you have to register it, so it's your responsibility to do so. If somebody is or use it in a restrictive format where you have those technologies where you don't let it be in a downloaded version or be it in an accessible version, so the technology will safeguard that. So in a legal fashion, as the ownership lies on you, and there will be like a lot of agreements which are going to give you a circle of protection, but the technology will be the implementing factor. So if you have a presentation or an image which is easily available and anybody can download it, people will do that. You have to take an action against it. But if you make it in a format where it cannot be downloaded, it cannot be used, it is watermarked and a number of things that are available, then the technology will restrict the usage, right? So both the remedies are available. Any other question?
If anyone wants to ask any question, you can unmute your mic and ask from the speaker, or you can also raise your hand, or either you can also type your question in the chat box. You can ask. We are open for the session for question and answer session for 4 to 5 minutes. If anyone asks want to ask any question, please ask. Otherwise, we will end the session, and the recorded session will be available on our YouTube channel. And the participants will get their certificates, e-certificates within 24 hours, and the recorded session video will be shared on your email ID, and as well as on your in your WhatsApp group. We will end the session at 12:10. Still 4 minutes are left. If anyone has any doubt, please ask. I think, ma'am, there is no any more questions. Only feedbacks are there. You can share your feedbacks with the ma'am also. I will share the link. I will share the link in the WhatsApp group and as well as in the email ID. Thank you, ma'am. Thank you very much for your time.
Thank you so much, and thank you everybody for listening patiently. If you have any questions, maybe you can reach out to Varun, or Varun can pass me on. I'll be happy to answer those.
Okay, ma'am. Thank you.
Thank you. Take care. Have a good day.